As of this week, temporary protected status for Haiti has officially ended, and hundreds of thousands of people, along with their employers, are scrambling to figure out exactly what that means, especially given how many times the actual end date has shifted over the past several months. Welcome back to US Visa News Hub. I'm Mr. Burhan, and if you're not subscribed yet, this is exactly the kind of update you don't want to miss. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation. Let's start with some background. Because Haiti's TPS story didn't begin this year, it goes back much further, and understanding that history helps explain why this termination feels so significant to so many people. Haiti has been designated for temporary protected status since 2010, following the devastating earthquake that struck the country that year. For 16 years, that designation has allowed roughly 350,000 Haitian nationals to live and work legally in the United States, building homes, careers, families, and communities around that protection. TPS was never meant to be permanent. By design, it's a temporary humanitarian designation tied to conditions in a person's home country, subject to periodic review and renewal by the Secretary of Homeland Security. But 16 years is a long time, and for many TPS holders, this status has effectively been the foundation of their entire adult life in the United States. Here's the timeline of how we got to where we are today, because this story has moved through several distinct stages over the past year, and a lot of the confusion right now comes from exactly how it unfolded. In November 2025, then Homeland Security Secretary Kristi Noem announced Haiti's TPS termination, originally set to take effect February 3, 2026. That termination got paused almost immediately. A federal district court in Washington, D.C. issued a stay on February 2, 2026, just one day before the termination would have taken effect, keeping status and work authorization in place while the underlying legal case worked its way through the courts. That stay held for months, giving Haitian TPS holders a period of continued stability, even as the broader legal battle continued in the background. The case ultimately reached the Supreme Court, and on June 25, 2026, the court ruled in a case called Mullin versus Doe, also referenced in some court filings as Trump versus Miot. It's genuinely worth being precise about what the court actually decided here, because a lot of early coverage oversimplified it in ways that created unnecessary confusion. The question in front of the court was not whether the government has the legal authority to end TPS designations. That basic authority was never seriously in dispute and has existed as part of the TPS statute for decades. The real narrower question was whether the people challenging Haiti's termination, who argued the decision was racially motivated, were entitled to a court order pausing the termination while their broader lawsuit continued to play out. The court said no for two main reasons. First, the TPS statute largely bars courts from second-guessing the Secretary of Homeland Security's determinations on TPS designation, extension, or termination. Congress built significant deference into this law when it originally created the TPS program. Second, the plaintiff's one potential way around that barrier, a constitutional claim that race was the real underlying motivation for the termination, didn't clear the legal bar needed to justify an injunction at this stage. In plain terms, this ruling removed the specific legal roadblock that had been keeping Haiti's TPS protections in place through the courts, even though it wasn't technically a direct ruling on the underlying merits of ending TPS itself. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your case. After that Supreme Court ruling came down, the case went back to the lower courts for what's called an implementing order, essentially the formal, technical process of translating the Supreme Court's decision into an actual enforceable termination date. That process typically takes around a month to complete. During that window, USCIS issued a series of short administrative extensions specifically to avoid an abrupt, chaotic lapse in work permits that could have caught hundreds of thousands of people and their employers completely off guard. The effective end date got pushed first to July 1st, then to July 10th, then to July 24th, and finally, to July 27, 2026, which is when Haiti's TPS designation officially and formally terminated. As of this week, employment authorization documents issued under Haiti's TPS designation carrying the A12 or C19 category codes are no longer considered valid, and employers are now formally required to re-verify affected employees' work authorization status through Form I-9. Now here's something worth knowing that adds a genuinely interesting and important wrinkle to this whole story, because it shows this wasn't a purely one-sided political issue. Congress actually made a real documented attempt to intervene on Haiti's behalf. In March 2026, a discharge petition aimed at forcing a floor vote to extend Haiti's TPS designation all the way through April 2029 gathered enough signatures to succeed, with support from 4 Republican members joining every single House Democrat. That effort led to an actual recorded House vote on April 16, 2026, which passed by a bipartisan margin of 224 to 204, with 10 Republicans and 1 independent joining Democrats in support. But here's the crucial detail that a lot of people don't realize. Passing the House alone does not make something the law of the land. Legislation also needs to pass the Senate and be signed by the President to actually take effect, and that broader legislative path never fully materialized, which meant this genuine bipartisan legislative effort ultimately did not stop the termination from taking effect this week. So there was real, meaningful, documented bipartisan political support in the House of Representatives for extending these protections. It simply wasn't enough, on its own, to change the final outcome. There's also genuine ongoing confusion right now about whether this termination has actually fully and completely taken hold on the ground, and I want to be honest with you about that, rather than pretending this is perfectly settled. Reporting from the Washington Post just this week described real, documented uncertainty even among people who have been closely tracking this case professionally, largely because the effective date moved multiple times throughout the month of July, and because the underlying litigation challenging the termination itself hasn't fully disappeared, even though the Supreme Court removed the main legal obstacle that had been blocking implementation up to this point. In other words, even experienced immigration attorneys and advocates are describing this moment as somewhat murky, which tells you this is a genuinely fluid, still developing situation, rather than a clean, fully resolved one. So, practically speaking, what does all of this actually mean if you're a Haitian TPS holder yourself, or if you're an employer with employees who hold this status? If you held Haiti TPS status, and your employment authorization document carried the A12 or C19 category code, that document is no longer considered valid work authorization as of July 27, 2026. This directly affects your legal ability to work in the United States, and depending on your individual immigration history and any other pending applications you may have, it may affect your broader legal status here as well. This is not a small technical detail, it's a fundamental change to your ability to remain employed and, for many people, to remain in the country at all without pursuing some other form of relief. If you're an employer with employees who presented Haiti TPS-based work authorization documents, you are now formally required to re-verify their employment eligibility through Form I-9. And as a general rule, you cannot continue employing someone who is unable to provide proof of current, valid work authorization, regardless of how long they've worked for you or how strong an employee they've been. Given how much this specific situation has shifted over just the past month alone, and given that litigation challenging the termination is still technically ongoing, even after the Supreme Court's ruling, this is exactly the kind of case where relying on outdated information, an old article, or something you heard secondhand, could create real, serious problems for your specific situation. If you're a Haitian TPS holder, the smartest first step is to check the official USCIS TPS Haiti webpage directly for the very latest guidance, since this page has already been updated multiple times this year to reflect the shifting legal timeline. Beyond that, it's genuinely worth speaking with a qualified immigration attorney about whether any other path might apply to your specific circumstances. This could include asylum, a pending family-based petition, a marriage to a US citizen, or another form of humanitarian relief you may not have fully explored while TPS was still providing stable protection. If you're an employer, this is a real moment to sit down and review your I-9 records, specifically for any employees who may be affected by this change, and to make sure your re-verification process is being handled properly and is fully documented, both to remain compliant and to give any affected employees the clearest possible picture of their situation. This story is clearly still developing, and given how many times the effective date has already shifted over the course of this year alone, it's genuinely worth continuing to watch this closely, rather than assuming that what's true today will necessarily still be true a month from now. We're going to keep tracking this story closely, and we'll bring you updates the moment there's a meaningful new development, whether that's further litigation, a new legislative push, or additional clarity from USCIS. If this was helpful, please share it with anyone you know who might be personally affected by this, a friend, a co-worker, a family member, or anyone in your community who has been navigating this uncertainty over the past several months. And subscribe to US Visa News Hub so you don't miss the next development in this story. Thank you so much for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.